Actual obstruction occurring on the doors accessible to the public. The record demonstrates that during Mr. Reard's protest, other members of the public entered and exited the courthouse with operation or the entrance without any interference with these activities. Defense Exhibit 3. The regulations text requires that conduct unreasonably obstructive to entrances and doors permanently block public access. There is no usual use to obstruct. Emergency exit is, by its very nature, not a usual use. That Mr. Reard's camera was certainly not unreasonably obstructing the emergency exit as it would easily step around to the side of the church emergency. The government's interpretation would criminalize any expressive activity in any courthouse entrance, regardless of whether that entrance is actually accessible or whether any person is actually in the camera placement as protecting those during activity. Mr. Reard's camera placement constitutes protecting the activity entitled to First Amendment protection, or as per 408 U.S. 681, which has been 448 U.S. 576. Possession of a recording of a document used in the offense represents core journalistic activity that cannot be criminalized absent compelling justification or intended to achieve legitimate aims. Mary Ann S. 460 U.S. 45. Government's demand for camera despite actual obstruction of government demonstrates that restriction aimed at suppressing documentation of political speech rather than addressing any legitimate regulatory concern. The obstruction provision is applied. It applies to Mr. Reard's peaceful camera placement in one door. Regulations switch to broad. Abstract protecting journalistic activity alongside any legitimate regulatory content. The Open Doctrine is designed to prevent the children of protected expression. Massachusetts v. Books, 491 U.S. 576, 584. Regulation that covers substantial speech in the First Amendment allows for the law to investigate. Indeed, the Congress of the City of Los Angeles, Jesus, 480. conduct in non-public forums. It is neutral as to content and viewpoint, narrowly tailored to protect significant governmental interests, and leaves open ample alternative channels of communication. An example, the defendant did in fact picket and protest outside the courthouse for an extended period of time without violating the regulations. S at 47. 2. Defendant's conduct directly interfered with those interests. The facts that can be established at trial will show the defendant's conduct directly contravened the government's interests, and the regulatory restrictions applied to these non-public spaces are reasonable. 1. Repeated defiance of posted rules and orders. Defendant was twice warned that recording devices and loitering were prohibited within the courthouse. His refusal to comply, under the guise of stress testing the system, demonstrated an intent to provoke confrontation rather than to lawfully exercise speech rights. Obstruction of entrances and emergency exits. By setting up a tripod camera in front of a designated emergency exit, defendant created a physical obstruction that threatened public safety and interfered with access to the building. 3. Disruptive noise and profane language. Defendant shouted profanities and directed loud, abusive language toward marshals and staff in a public lobby, disturbing both courthouse employees and members of the public conducting official business. Such conduct falls squarely within the prohibition on loud and offensive noise. 4. Escalating conduct despite prior warnings. Defendant's escalation from handheld recording devices to a tripod and camera setup, signs pressed against entrance doors and parading in and around the entrance and the lobby shows deliberate disregard for lawful orders and for the rights of others to access the courthouse. And his applied challenge will eventually fail after a trial of the matter. The defendant's arrest and prosecution are based not on the content of his message, but on his disruptive, unsafe, and unlawful conduct. D. Defendant's selective and vindictive prosecution claims fail. Defendant also asserts that this case represents either selective claims collapse under settled Supreme Court precedent. Prosecutorial charging decisions are entitled to a presumption of regularity. United States 517 U.S. 456, 464. To overcome that presumption, evidentiary burden. ID at 463. Defendant falls far short. 1. Legal standards for selective prosecution. A selective is not a defense to the merits of the charge, but an assertion that the prosecution itself is constitutionally infirm. C. For example, White v. United States 407. To prevail, the defendant must show 1. Discriminatory if others similarly situated have not been prosecuted for similar conduct, and 2. Discriminatory purpose, that the prosecution was motivated by impermissible considerations such as race, religion, or the exercise of protected rights. ID Armstrong 517 U.S. at 465. The burden is a demanding one. Armstrong 517 U.S. at 463. Courts require clear evidence before finding that prosecutorial discretion has been abused. ID at 464. Here, defendant cannot establish either prong. He proffers no evidence that other individuals who engaged in comparable conduct, repeatedly bringing prohibited recording devices, obstructing courthouse exits, and creating loud disturbances, were not prosecuted. Nor does he provide evidence that the factor. Instead, the record demonstrates that the government responded to his repeated violations of posted rules and warnings, his obstruction of emergency exits, and his disruptive and abusive behavior. Without proof of both discriminatory effect and purpose, but distinct claim. It arises when a prosecutor retaliates against a defendant for exercising a legal right. See Blackledge v. Perry, 417 U.S. 21, 27, 28. To prevail, a defendant must show either actual vindictiveness, that the prosecutor acted with genuine animus, or circumstances giving rise to a presumption of vindictiveness. And to find vindictiveness in the pretrial charging context. In Goodwin, the court held that no presumption arises merely because the government chooses to defendant asserts a procedural or constitutional right. ID at 384, only in the post-conviction. ID at 376, 78, defendant has no facts, either actual or presumptive vindictiveness. The government's decision to prosecute arose not from retaliation but from defendant's escalating pattern of disruptive and unlawful conduct after multiple warnings, or from punishing him for exercising rights. The government acted to protect courthouse safety and ensure compliance with law. 3. Defendant cannot meet either burden. The record makes plain that defendant's prosecution stems from his conduct, not his viewpoint. He was prosecuted because he repeated federal property, obstructed access to emergency exits, and created loud and abusive disturbances inside a courthouse around an entrance and exit. The defendant offers no evidence that similarly situated individuals were treated differently, nor any proof that prosecutors acted with discriminatory or retaliatory animus. The mere fact that defendant styled himself as an independent journalist does not immunize him from neutral rules regulating conduct in non-public forums. See Brandsburg v. Hayes, 408 U.S. 665, 683. Because defendant cannot satisfy the rigorous standards for selective or vindictive prosecution, these claims provide no basis to dismiss the information. Sixth conclusion. Only a fact-based facial challenge is properly before the court prior to trial. Section 102-74.390 is a facially valid, content-neutral and viewpoint-neutral regulation governing conduct on federal property. Its application here was reasonable, narrowly tailored, and necessary to preserve the safety, order, and functioning of a federal courthouse. Defendant's prosecution was not selective or vindictive, but the predictable result of his repeated, willful violations of lawful regulations and warnings. For the foregoing reasons, the court should deny defendant's motion to dismiss the bill of information. Respectfully submitted. Zachary Kelly, United States Attorney. S/Ladonna Murphy, Ladonna Murphy. That, or no. 32 Assistant United States Attorney, 800 Lafayette Street, Suite 2200 Lafayette. Matthew Reardon. Defendant's reply memorandum in support of motion to dismiss the bill of information. Now into court, through the undersigned counsel, comes defendant Matthew Reardon, who respectfully submits this reply memorandum in further support of his motion to dismiss the bill of information. Mr. Grounds that the charged conduct constitutes protected expression under the First Amendment rights of free speech, press, and petition for redress of grievances, and that 40 or Section 102 to 74.390 is facially overbroad and unconstitutional as applied to his peaceful journalistic and protest activities conducted in a traditional form. For the reasons set forth in this memorandum, this court should dismiss all charged established constitutional principles. Table of contents, table of authorities, statutes, introduction. The government's opposition fundamentally misconstrues the nature of Mr. Reardon's constitutional challenge to defending the facial validity of 41 CFR. Section 102 to 74.390, arguing that only the facial challenge is ripe for adjudication pre-trial. Golf rest at 8. But Mr. Reardon has not mounted a facial challenge to the regulation. His arguments concern how the regulation was applied to his specific for political protest and journalistic documentation on courthouse steps. The government acknowledges that whether the regulation may be dismissed prior to trial depends on whether the infirmity in the prosecution is essentially one of law or involves determinations of fact. At 8, while the government asserts factual disputes exist, the video evidence of the arrest resolves the material facts. The video establishing was outside the courthouse building, that his camera was positioned under the covered exterior portico rather than inside any vestibule, that he moved the camera when directed, and that he was arrested immediately after complying. These facts are not genuinely in dispute. The legal question presented is whether the government may criminalize this conduct consistent with the First Amendment. Under clearly established second reply argument. 8. This prosecution government constructs its response around defending the facial constitutionality of Section 102 at 10-16. This approach fails because Mr. Reardon does not challenge the regulation's facial validity, nor does he contest that certain courthouse interior spaces may constitute non-public forums where the government may impose reasonable restrictions. 1. There is a functional and constitutional difference between the outside of the courthouse and the interior of the courthouse. The central dispute in this case concerns the proper characterization of the space where Mr. Reardon's protest occurred. The government argues that courthouse lobbies, foyers, entrances, elevators, and office spaces are paradigmatic non-public forums. At 11, the government space to the interior and is therefore subject to the same restrictions as interior courthouse spaces. At 4. This argument fundamentally misunderstands both the facts and the law. As a factual matter, Mr. Reardon was outside the courthouse. He stood under a covered exterior walkway providing public access to the building. The presence of a roof over this exterior walkway does not transform it into an interior space. Millions of Americans walk under covered exterior walkways every day when approaching buildings. These covered walkways provide weather protection while remaining exterior public spaces. The government's characterization of the portico as a transitional space to the interior is particularly problematic. At 4. Under this theory, any covered area near a courthouse entrance would lose First Amendment protection. This theory would effectively eliminate the right to protect house entrances, as nearly all modern courthouses feature some form of covered entrance. The government cites no authority for the proposition that covered exterior walkways lose their public forum character. More fundamentally, the government's approach conflates the question of where speech occurs with the question of what forum protections apply. The government appears to assume that any space proximate to courthouse doors must be subject to the Supreme Court precedent establishes precisely the opposite principle. Exterior areas providing public access to government buildings retain their traditional public forum character even when immediately adjacent to the building. Government's argument also ignores the functional and historical characteristics that define traditional public forums. Courthouse steps and exterior walkways are places where citizens have gathered throughout American history to judicial proceedings, government conduct, and matters of public concern. Citizens approach courthouses on these exterior walkways to observe judicial proceedings, to serve as jurors, to appear as parties or witnesses, and to engage with the justice system. These spaces facilitate the citizenry's interaction with the core government function, the administration of justice. This historical and functional connection to democratic self-governance confirms their status as traditional public forums. The government's attempt to extend the non-public forum analysis to exterior covered areas would represent a dramatic and unprecedented contraction of First Amendment protection. 2. United States v. Grace controls this case. The Supreme Court's decision in United States v. Grace, 461 U.S. 170. The court addressed a statute prohibiting displays and demonstrations on Supreme Court grounds, including the public sidewalks surrounding the court building. The government argued that these sidewalks, though publicly be property occupies a special position in terms of First Amendment protection and will not lose its thus government property that has been dedicated to a use other than as a forum for public expression. 9. The access to the court building did not eliminate their public forum character. The exterior steps and covered walkway of the Lafayette Courthouse have an even stronger claim to traditional public forum status than the perimeter sidewalks in Grace. Courthouse steps are not merely adjacent to a courthouse. They are the primary pathway citizens use to access the courthouse and engage with the justice system. Throughout American history, citizens have gathered on courthouse steps to voice their views about judicial proceedings, government conduct, and matters of public concern. Courthouse house courtrooms and judges. They house government agencies like the U.S. Marshal Service and U.S. Department of Justice that citizens might want to protest or from whom they might seek redress. This functional and historical connection to core democratic processes confirms their status as traditional public forums. The government's only response to grace is to argue that the court distinguished the building's interior, which was not a public forum. Goff, Res. At 12. This is true but irrelevant. The question in this case is not whether the courthouse interior is a public forum. Mr. Reardon was outside the courthouse. The question is whether exterior areas providing public access to the courthouse retain their public forum character. Grace tells us the answer is yes. The government's attempt to characterize the covered exterior portico as functionally equivalent to the courthouse interior cannot be reconciled. The government's attempt to characterize the covered exterior portico as functionally equivalent to the courthouse interior cannot be reconciled with grace. The sidewalks in Grace were adjacent to the Supreme Court building and provided direct access to the court's entrance doors. If proximity to doors and direct access to the building eliminated public forum status, then the sidewalks in Grace would not have been protected. The court's analysis focused on whether the space where citizens historically gathered to engage with their government, not on whether the government's opposition effectively asked this court to distinguish. Nothing in Grace suggests that covered exterior walkways lose their public forum character. Books feature awnings, bus shelters, or other weather protection without losing their status as traditional public forums. The presence of a roof does not transform exterior space into interior space or eliminate public forum protections. 8. The government's reliance on Hodge v. Talkin is misplaced. The government attempts to avoid grace by relying on the out-of-circuit case Hodge v. Talkin, 799 F 1145, which addressed the Supreme Court's enclosed marble Goff Res. At 13 to 14. But Hodge carefully limited its holding to the specific architectural features that distinguish that plaza from traditional public forums. The Hodge court emphasized that the plaza is an elevated terrace, paved in distinctive white marble, surrounded by a low marble wall. That architectural statement, the court found that these features conveyed to visitors that they had entered some special type of enclave, ID. At 1158, critically, the regulation at issue in Hodge was not the general federal property regulation involved here. Instead, Hodge concerned 40 U.S.C. Section 6135, a statute specifically addressing the Supreme Court's grounds and plaza. That statute was enacted to govern a particular architectural space. The distinctive elevated marble was constructed in the 1930s. By contrast, 41 CFR, Section 102 to 74.390, is a general regulation applicable to all federal property. It was not enacted to address any particular architectural feature of the Lafayette Courthouse. It does not identify courthouse steps or covered walkways as restricted zone space like the Supreme Court Plaza. It enacts a specific statute for that purpose, as it did with 40 U.S.C. Section 35. The government cannot use a general property regulation to accomplish the same result for every federal courthouse without regard to the traditional public forum character of courthouse steps and exterior walkways. More fundamentally, the exterior steps and covered walkway of the Lafayette Courthouse possess none of the distinctive characteristics that made the Supreme Court Plaza in Hodge something other than a traditional public forum. The Lafayette Courthouse exterior is not enclosed by marble walls. It is not paved in distinctive materials. It does not feature fountains, flagpoles, or benches creating an integrated architectural statement. It is not an elevated terrace separated from surrounding public areas. It is a standard courthouse entrance featuring steps and a covered walkway providing direct public access from the sidewalk to the building. These are functional outdoor pathways open to the public and used for public events including Mardi Gras and Festival International de Lucien. The government includes a photograph of the Supreme Court Plaza in its opposition brief to support its reliance on Hodge. Gov. Raspet 13. This photograph actually undermines the government's position. The Supreme Court Plaza is visually and architecturally distinctive. It is an elevated, enclosed, formally designed forecourt that clearly communicates its character as a special space. The Lafayette Courthouse exterior has no comparable features. It is an ordinary courthouse entrance with steps and a covered walkway. No visitor would understand it as some special type of enclave separate from the surrounding public areas. 799 F. At 1159, Hodge does not hold that any exterior area near courthouse doors loses public forum protection. It holds that a specific, architecturally distinctive elevated plaza with unique features may be treated differently from ordinary sidewalks and walkways. The Lafayette Courthouse exterior has none of these distinctive features. 4. Even under non-public forum analysis, this prosecution accept the government's characterization of some portion of the exterior courthouse area as a non-public forum, a characterization Mr. Reardon contests the prosecution still fails. In non-public forums, restrictions must be reasonable and viewpoint neutral. Goff Rasp. At 10 to 11, the government cannot meet this standard. Prosecuting peaceful political protest and journalistic documentation conducted outside a courthouse is not reasonable in any meaningful sense. The government asserts its interests as ensuring the security, order, and functioning of judicial proceedings. Goff Rasp. At 3. While these are legitimate interests, Mr. Reardon's conduct threatened none of them. He stood outside the courthouse holding signs. He spoke critically of government officials. He positioned a camera outside the building to document his protest. None of this conduct created any security threat or interfered with courthouse operations. The government does not allege that Mr. Reardon attempted to enter the building with prohibited items. The government does not allege that Mr. Reardon blocked anyone's access to the building. The government does not allege that Mr. Reardon disrupted any judicial proceeding. The government does not allege that any person was unable to enter or exit the courthouse due to Mr. Reardon's presence or equipment. The government does not allege any actual security threat or any actual interference with courthouse operations. The government emphasizes that Mr. Reardon placed his camera directly in front of one of the available emergency exits. Goff Rasp. At 6. But several points undermine this rationale. The door was locked and not in use as an entrance during normal operations. The government acknowledges the door served as an emergency exit rather than as a public entryway. The camera was outside the courthouse. The door opened outward onto the exterior area where the camera was positioned. Any object positioned outside an outward opening door would be pushed aside by the door itself if the door were open in an emergency. The camera could not physically prevent the door from opening because the door's outward swing would displace any external object. Most importantly, Mr. Reardon moved his camera when directed to do so. At that point, even the government's speculative obstruction theory evaporated, yet the government arrested him anyway. This sequence of events demonstrates that the asserted concern about obstruction was pretextual. If the government's concern was genuinely about the camera's position creating a safety hazard, the appropriate response after Mr. Reardon moved the camera would have been to allow him to continue his protest. Instead, the government arrested him and seized his recording equipment, preventing him from continuing his constitutionally protected activity. Second, the enforcement is not viewpoint neutral. The government issued a bolo alert on Mr. Reardon based on his journalism critical of federal law enforcement when he protested this surveillance. The government's emphasis on the profanity in Mr. Reardon's speech reveals the viewpoint-based nature of enforcement officials. The government's focus on Mr. Reardon's criticism rather than on any actual security concern. This prosecution targets his message. Even under the more deferential standard applicable to non-public forums, the government cannot criminalize peaceful political expression conducted outside a courthouse without demonstrating actual interference with legitimate governmental interests. The government has made no such demonstration. The government points to no disrupted proceeding, no blocked access, no security threat. The government's case rests entirely on its disapproval of Mr. Reardon's message and its discomfort with his criticism of the U.S. Marshal Service. Content-based discrimination requiring strict scrutiny. The government argues that Section 102 to 74.390 is content neutral because a person who obstructs an entrance while praising the government is treated no differently than a person of Rasp. At 15. This response misses Mr. Reardon's discriminates based on content. He argues that the government's enforcement demonstrates content-based targeting. The evidence of compelling and specific. Before the August 25, 2025 arrest, the U.S. Marshal Service regarding Mr. Reardon. This alert was based on Mr. Reardon's journalistic activities documenting federal law enforcement conduct at the Lafayette Courthouse and other federal facilities. Mr. Reardon's journalism, published through With the People News, has been critical of certain U.S. Marshal Service practices and procedures. The bolo alert itself constitutes evidence of viewpoint-based targeting. Mr. Reardon was engaged in lawful journalistic activity protected by the First Amendment. The issuance of a bolo alert for a journalist engaged in protected news gathering demonstrates that federal authorities were in tracking Mr. Reardon based on the content and viewpoint of his journalism. This is precisely the type of content-based enforcement strict scrutiny. And the government does not address why other individuals who engage in comparable conduct during public events such as parades and festival international delusion occurring in the same locations are not prosecuted for creating loud or unusual noise or temporarily congregating near courthouse entrances. C. The loud or unusual noise or a nuisance provision violates the First Amendment as applied to Mr. Reardon's protected speech. 1. Mr. Reardon's vocal expression constitutes protected political speech. The government characterizes Mr. Reardon's speech as shouting profanities and directing obscene comments at marshals combined with obstruction and refusal to comply with lawful orders. Of respect 7. This characterization fundamentally misunderstands political protest and the protection it receives under Edwards v. South Carolina, 372 U.S. 229. In Edwards, the Supreme Court protected protesters who engage in boisterous, loud, and flamboyant conduct while expressing political grievances. The court reversed breach of peace convictions even though the protesters became loud and unruly after police ordered them to disperse. Even though the protesters refused to comply with the police orders to disperse. At 235 to 38, the Supreme Court has emphasized that speech may indeed best serve its high purpose when it induces a condition of unrest, creates dissatisfaction with conditions as they are, or even stirs people to anger. Terminillo v. Chicago, 337 U.S. 1, 4. Mr. Reardon was outside the courthouse voicing criticism of government officials and expressing grievances about perceived government overreach. The fact that he used profanity does not remove constitutional protection. The fact that his speech may have offended officials does not justify prosecution. Citizens do not forfeit First Amendment protection when they express political views in language that government officials find offensive. 2. Unconstitutional vagueness of the noise provision. The government cites out-of-circuit precedent rejecting not engage with Mr. Reardon's specific argument when applied to vocal political. The terms loud or unusual noise or a nuisance lack constitutionally adequate objective standards. Goff, rest. What volume level constitutes loud for purposes of criminalizing speech outside a courthouse? The regulation is passionate political oratory loud? Is any volume audible inside the building loud? Is a raised voice loud? Is the music blasted at the Scene Welker stage during Festival International de Lucien directly in front of the courthouse loud? Are the screams of joy from Mardi Gras revelers on the courthouse steps loud? These questions have no answers in the regulation's text. The regulation provides no decibel threshold, no distance measurement, no comparison to ambient noise levels, and no objective criteria whatsoever. This absence of standards means that enforcement depends entirely on the subjective judgment of the officer, creating the risk of viewpoint-based or discriminatory enforcement. Colander v. Lawson, 461 U.S. 352, 358. City of Chicago v. Morales, 527 U.S. 41, 56. Unusual is equally standardless. Unusual compared to what? Typical conversation. Ambient street noise, the volume is during public events, the volume at which government officials themselves speak. The regulation provides no comparison point, and nuisance is entirely subjective. What constitutes a nuisance depends on whether the listener agrees with or is offended by the speaker's message. A listener who supports Mr. Reardon's message might view his protest as important civic engagement enforcement. The absence of objective standards invites the evident in this case. Mr. Reardon's speech was no louder or more unusual than speech at numerous public events occurring in the same location, but his speech criticized federal officers. That criticism, not any objective violation of noise standards, motivated this prosecution. D. The unreasonably obstructs the usual use of entrances provision is unconstitutional as applied to Mr. Reardon's camera placement. 1. The regulation requires obstruction of usual use. The regulation prohibits conduct that unreasonably obstructs the usual use of entrances. 41 CFR. Section 102 to 74.390. The government argues that Mr. Reardon obstructed an emergency exit by placing a camera outside a door. Goff, rest. At 6 to 7. This argument fails on multiple grounds. First, the term usual use has meaning. A door that remains locked to public access and serves only as an emergency exit is not in usual use during normal operations. The usual use of an emergency exit is to remain closed and locked. An emergency exit's use in an actual emergency is not its usual use. It is its exceptional use. The usual use of a main entrance is for people to enter and exit. The usual use of an emergency exit is to remain locked and closed. The government's interpretation would read the word usual out of the regulation entirely. Second, Mr. Reardon's camera was outside the courthouse. The government acknowledges the door was locked. Goff, rest. At 6. and the undersigned's experience. This door remains locked at all times during normal courthouse operations, and the public enters and exits through different doors. Mr. Reardon pointed this out to Marshal Nugent. A camera positioned outside a locked door that the public cannot access does not obstruct the usual use of that door. Third, the door opens outward. Any object positioned outside an outward opening door would be pushed aside by the door itself if the door were open in an emergency. The camera could not physically prevent the door from opening because the door's outward swing would displace any external obstruction. This emergency egress occurred or could occur. Fourth, even assuming the camera's position could theoretically impede emergency egress in some hypothetical emergency, Mr. Reardon moved the camera when directed to do so. The government disputes whether his compliance was immediate. He first responded with profanity and only moved after rest. As 7. When verbal protest combined with physical compliance is not obstruction, the First Amendment protects Mr. Reardon's right to voice disagreement. He moved his camera away from the door. At that point, any theoretical obstruction ceased to exist. The government arrested anyway, demonstrating that the asserted concern about obstruction was pretextual. 2. The government's argument that the moved camera still obstructed access lacks merit. The government suggests that even after Mr. Reardon moved his camera, it's still close enough to continue to film inside the courthouse and would have obstructed foot traffic into or out of the courthouse if left recording at that location. Rest. As 7 to 8. This argument is unsupported and contradicted by the video evidence. Mr. Reardon moved his camera away from the door. He then stated, "I'm fine right here," indicating his understanding that the camera no longer obstructed the entrance. At this point, the government seized his equipment and arrested him. If the camera's new position still created an obstruction, Marshal Nugent could have directed Mr. Reardon to move it further. Instead, the government chose immediate arrest and seizure. The government's assertion that the camera would have obstructed foot traffic is flatly contradicted by the video evidence. Moreover, the record shows that members of the public continued entering and exiting the courthouse throughout Mr. Reardon's protest without incident. No one's access was impeded or obstructed. The government points to no instance of anyone being unable to enter or exit due to the camera's position. 3. Camera placement as protected news gathering activity. Mr. Reardon positioned his camera outside the courthouse to document his protest for We the People News, his journalism platform with over 3,000 subscribers. This positioning of recording equipment to document newsworthy events constitutes protected First Amendment activity. The government does not dispute Mr. Reardon's journalistic purpose. Rest. And 4. If the government had a genuine concern about the camera's position creating a safety issue, reasonable accommodation was available. The government could have directed Mr. Reardon to position his camera in a specific location outside the courthouse that would allow him to document his protest while addressing any safety concerns. Instead, the government chose the most restrictive response, seizing the equipment and arresting the journalist. The government's own delay undermines its safety rationale. If the camera created an urgent safety hazard, why did marshals wait over 20 minutes before addressing it? Rest. At 6 to 8, the government provides no explanation. The more plausible explanation is that the camera's position outside a locked door created no actual safety concern, and the government invoked the obstruction provision as a pretext for suppressing Mr. Reardon's protest and journalistic documentation. Third conclusion. Mr. Reardon's conduct falls squarely within the Supreme Court's protection for political protest in traditional public forums. His immediate compliance with law enforcement directives, peaceful interaction with the public, and legitimate journalistic purpose distinguish this case from any legitimate application of Section 102 to 74.390. The government's prosecution violates clearly established First Amendment precedent and cannot survive constitutional scrutiny. The regulation's application to Mr. Reardon's conduct fails every constitutional test. It restricts protected expression in a traditional public forum, discriminates based on the content of his criticism, lacks narrow tailoring to serve legitimate governmental interests, and provides inadequate notice of prohibited conduct. Wherefore, defendant Matthew Reardon respectfully requests that this court grant his motion to dismiss the bill of information and dismiss all charges against him. Respectfully submitted, Rebecca L. Hudsmith, Federal Public Defender. Dustin C. Talbot, Appellate Chief, Federal Public Defender's Office, Middle and Western Districts of Louisiana, 102 Versailles Boulevard, Suite 816, Lafayette, Louisiana, 70,501. Telephone, 262 to 6,336. Certificate of Service. The undersigned hereby certifies that on October 6, 2025, a copy of the foregoing was filed electronically with the clerk of court using the CM/ECF system. Notice of the filing will be sent by operation of the court's electronic filing system to all counsel of record. /Dustin C. Talbot.